Our next speaker will be Roy Halbeck. Roy?
Ladies and gentlemen, I first want to express my appreciation for the opportunity to be here this afternoon. I don't have any prepared statements. I never liked them, but I did take a few notes. I'd like to comment on one or two things that I think may not have been said and might be helpful to you in your thinking. Mr. Macy mentioned the new relationships, and anybody'd be a fool not to admit that they are an improvement. However, I think I ought to tell you that it wasn't always so. The executive order itself, as he said, followed 50 years after the Lloyd La Follette Act. But neither one of those things came about simply by themselves. They came about only because of unions. The Lloyd La Follette Act, for those of you who aren't familiar with its history, resulted from the fact that two presidents of the United States, Theodore Roosevelt and William Howard Taft, issued orders that forbade the officers, and it was aimed at one organization only, of a then fledgling union from petitioning the Congress for a redress of their grievances. I happen to be a representative of the union that was involved. It took an act of the Congress to give employees a right that is stated in the Constitution. And it was 50 years from that day, or approximately 50 years from that day, until we got the Executive Order 10988. Lest anybody be in any doubt, that didn't just happen. That resulted from the demands of a union. It was the introduction of legislation in 1949, as I recall the year, by a then junior congressman from the state of Pennsylvania, George M. Rhodes, who introduced what was then known as a Union Recognition Bill that eventually led to Executive Order 10988. And the day that bill was introduced, I'm confident that George Rhodes and I were the only two people in Washington that thought it had any future. As time went on, it began to gather adherents. And ultimately, a senator from Massachusetts, the late John F. Kennedy, was one of those who introduced such a bill. It was out of his conviction that there was merit to the proposal that came, first the task force and then the executive order. I cite those things merely as a preface to saying that unions are here in government to stay. Unions, and I mean unions in the true sense of the word, not employee associations, unions are here to stay, and they're never going to be satisfied until they get conditions at least approximately equal to conditions enjoyed in private industry. Now, I'm not here advocating the right to strike. My union was the first union ever to become chartered by the then American Federation of Labor, and in its founding constitution, you'll find language that's carried there to this day. We believe that legislation and not the strike is the solution, lies the solution to our grievances. We have had access to the Congress. It's largely because of that access to the Congress that conditions have improved. Nobody gave us anything. It was things that our intelligence, our persuasiveness, if you will, convinced the Congress ought to be granted. We don't now advocate the right to strike. Philosophically, I could discuss that at some length. But I'd be less than honest if I didn't tell you that there were in government circles a considerable number of people who are no longer so sure that that position is valid. In my own convention in Louisville, Kentucky, just last August, for the first time in my knowledge, and that goes back a long, long way, we had a resolution suggesting an amendment to the Constitution to repeal the no-strike clause. It was defeated. It was defeated overwhelmingly. But I'd be less than naive if I didn't tell you that a few hot pots could have made that a lot closer than it was, because there was a feeling of unrest, and that unrest is there despite the fact that anyone can readily demonstrate that there have been improvements resulting from Executive Order 10988. Unfortunately, the improvements haven't, as some people evidently thought, changed the world overnight, because so-called management rights, so-called employee rights, have caused a vast void. There's no great agreement on whose rights end where. Agencies, and I'm not speaking in the terms of federal agencies, I'm speaking of actually post offices in the Postal Service, have not overwhelmingly reacted in favor of the President's executive order, because a lot of them didn't believe that it applied to them. If there was any acceptance at all, it was only because they were dragged screaming and reluctantly to the altar. And it was only because you had unions that they were dragged to that altar. We find now, despite the fact that in the Postal Service at least, we've solved some of the problems, I think, that are being currently experienced in other departments of the government. It's only because we have a national agreement, because there was a sufficient organization on a national scale, that we've been able to make agreements that have some force and effect. We're not bothered by anybody changing regulations, because our national agreement provides that any regulations in conflict with that agreement are amended and repealed. And that can be done through negotiations under the executive order. But it can only be done at a national level where those regulations are written. I believe very much in the executive order, which will celebrate its 5th anniversary just 1 week from today. I think it was perhaps the greatest single step ever taken in the direction of improving employee management relations in government service. But I believe that there is room for further improvement. I've discussed with Mr. Macy, I think I've discussed with Vern Gill, I've discussed with others in government, the general feeling among unions, such as the one I represent, that there has to be some sort of a central labor management panel, if you please, similar to the NLRB or whatever or something of that nature, that will be able to handle some problems that have proven almost impossible of solution. We make a charge of unfair labor practices, and some of them appear to me to be open and shut cases. They make informal attempts to resolve them, and so far, within their limitations, they have been resolved, but not without leaving a great deal to be desired in terms of accomplishment. We've had instances where postmasters, for example, have not on 1 or 2 or 3, but on as many as 5 occasions, very definitely violated the agreement that the Postmaster General signed. We have a long, drawn-out process involved with red tape, as necessarily it must be, that results in those being brought to the attention of a regional director, and eventually the postmaster is told to cease and desist. But when he turns around and does it the 6th time or the 7th time, you begin to wonder whether you've got an agreement worth the paper it's written on. And in cases like that, I think we have some justification for the belief that there ought to be some punitive arrangement somewhere that can at least make him toe the mark when the Postmaster General himself sets the mark. In short, I believe that we have made tremendous progress in the labor management field, but I believe that there is definitely a place in the structure for the mediation and conciliation service. I think that something can be worked out that will make available not only to the agencies, but if you will, to local managers, the services of people who are skilled in the art of getting agreements, making people understand what the common problems are, and securing solutions. I think you have a part to play in that setup. And I want you to know that so far as the organization I represent is concerned, we're going to continue our efforts to make that possible. Thank you very much.
Our last speaker will be Eli Rock. Although it's obvious from the title of this program that our main thrust and our main discussion later on will be on the federal sector, or federal employees, we have not prohibited Eli from making comments about similar problems for state and municipalities. Eli, go ahead.
The lines between federal areas of this problem and local and state areas are not always clear. I think this is all part of a larger historical trend that some of us predicted a long time ago. It was a little slow in picking up the speed it has picked up recently, but I think at this time any reading of the daily newspaper will persuade you that the trend is now with us. Just as an aside and as an indication of the confusion between, or possible confusion between public and local and federal lines on this, I was at a conference recently in the Middle West at a university where I spoke to a group of labor union people on this problem, and one fella got up and he was the head of a firefighters union in a city that, in a state that had no state mediation agency, and that union, that was one of the firefighters unions that had actually gone out on strike in some limited way, I believe. And after my talk, he got up and he said, we couldn't get anybody to help us, any outside agencies. We tried to get the Federal Mediation Service in to help us settle this dispute, and I wrote a letter to this fellow Simpkin, and I got back 2 pages of the worst double talk he ever saw, telling me why he couldn't intervene. And I said, well, no, wait a minute. He operates under certain legislation, and he only has certain jurisdiction. And he says, you're giving me double talk too. And finally, to get off the hook, I said, well, I'm going to see Mr. Simpkin in a month or so. I'll ask him when I see him why he can't help you. And that's and this guy sent me a letter this past week reminding me that I have to ask you, Bill. There's no question that the heat of this problem is greater at this point at the state and local level than it is at the federal level. There are a lot of reasons to explain for that. A big part of it at all levels has been the resistance of government to this whole idea of collective bargaining, and the feeling for years and years that it was somehow incompatible with government. We have a case in the state of Pennsylvania, Charlie Dowd may know about it. They passed a law some time ago saying that you can't strike in Pennsylvania, but in return for that, public employees that is, but in return for that, a public employee with a grievance can ask for a fact-finding board. Well, a group of employees tried to organize someplace, and this agency, this Board of Prisons in Philadelphia, fired the 2 ringleaders of this. So the union said, all right, well, we'd like to invoke the fact-finding board for these 2 people, and the agency said, oh no, it says employees. These people are no longer employees, they've been fired. That was carried to the State Attorney General of Pennsylvania, who nodded sagely and said he thought that was a reasonable interpretation, and he upheld the local government. And then it went to the Supreme Court of Pennsylvania in the famous case of Broadwater versus Otto, and that court sustained that position. In the immortal words of my good wife, whose mind often works considerably faster than some of the cumbersome phraseology of the English language, I wish Bill Wirtz were here. He's an expert in this field. This was a case where we bought the wrong pig in the poke and the roosters came home, referring to this whole field. There has been, just to give you some feel of how this problem is hitting us, in the past 3 years, unions like the American Federation of Teachers have grown 69%. The American Federation of Government Employees, at least the figures I've seen, show a 61% gain. And there are 6 unions in the field now with over 100% membership. By contrast, in the last over 100,000 members. By contrast, in the last 3 years, the AFL-CIO growth generally has been about 7%. In the last 10 years, public unions have grown 59%, while private industry unions have declined 5%. These are some figures that Business Week used recently. Now, you could talk for days about some of the special problems in this field. I would simply try to point up on the assumption that all third parties, mediators, arbitrators, and whatnot, are going to get into this increasingly. And by the way, you'll find it a refreshing experience as you get into it to get these new problems. All of you are trained to get into a new and strange situation. You get into an industry that you've had no familiarity with, and you learn quickly how to pick up the facts and the expertise of that industry. This is part of our training and expertise, but this is considerably different than that, and I think will require somewhat more preparation. But I think you will find it a refreshing variation from some of the things we've been used to doing. Just a few examples of the types of problems you're likely to experience. I think you will find right off the bat more problems of procedure, just in terms of how many people are there going to be on the committees? Will the agency pay for the time of negotiating? The union members of the negotiating committee, this is one that private industry wouldn't have dreamed of, but this comes up in a different way in private industry, in the public service. Now, I'm talking of experiences perhaps at the federal level to a primary extent at this point, because that would presumably be the area that you're going to get into eventually on some basis. The hours of the negotiating meeting will be subjects of controversy. This whole procedural question, right off the bat, before you ever get into issues, you may find a lot of hassling over that. And there's no question that there will be much more inexperience on the part of the participant. Those ABCs may be in a different language too than even we've understood, but there will be a lot more of those fundamentals to be considered. There will certainly not be the acceptance of the kind of collective bargaining that you have seen, that I have seen in private industry. It is developing, but there will be all kinds of crazy things happening. There was a teachers' union in a suburb of Chicago recently that insisted on having public collective bargaining right in the open. This wasn't just a gimmick. They insisted on it, and it was some wealthy suburb, and the bankers' wives and the lawyers' wives and some of the bankers themselves and even a high school class that was studying labor management relations sat in and watched those negotiations. And they settled. Now, there may have been some, if there's one sacred cow that we all have cherished, it's the idea of privacy, of bargaining, of collective bargaining. But anything might go in this field. Now, there will be a very serious problem, and there is a very serious problem, which has already been touched on, regarding the highly restricted scope of bargaining in this field, particularly at the federal level. At the local and state levels, they are, in one way or another, getting into the bread and butter issues of, in bargaining, of wage increases, hours, overtime, payment for overtime, pensions, health and welfare. At the federal level, as you know, the executive order excludes items of this sort, and those are left to Congress, where the lobbying, as distinguished from the collective bargaining process, applies. There's a whole subject to be discussed about the relative virtues of lobbying versus collective bargaining in this field. You will, but even with those items that are left for bargaining by local agencies, as Mr. Beaumont has pointed out, there is vast confusion between regulations, personnel manuals, and subjects that might be bargained upon. And there's no question that it's an easy gimmick if you're in the management position to, if you don't want to bargain about something, to say that's a regulation, and all of a sudden it acquires some kind of holy aura, and it's the same reaction as some man in private industry who would like to do that. He really would prefer not to bargain about that. But this is ingrained deeply. These have been the procedures for a long time, and they involve questions of sovereignty and discretion, policy that government can't delegate, and you will run into this as you try to find areas that can be bargained on. There are no impasse resolution procedures as we have known them in private industry. There's a real problem regarding enforceability of the contract. It's a relatively simple thing in private industry. Of course you're going to enforce the contract. You have arbitration and whatnot, but binding arbitration is relatively rare in this field. Advisory arbitration is beginning, which is kind of a contradiction in terms because arbitration denotes something that's binding, like a court decision, in fact more binding than a lower court decision. But advisory arbitration is being used at the federal level, I understand, with growing success. They don't even have that in most of the local and state setups. There's a real problem of agreeing when to call the mediator in. There will be a temptation by the unions in this field particularly because they don't have the strike weapon and they don't have a way of putting pressure on the management side of the table to use the threat of calling in the mediator or some third party as a way of putting pressure on. And the other side may not agree to that, and it may shortcut the bargaining that should take place before a mediator comes in. There will be all kinds of problems of this sort. I think the unions will tend to look on the mediator as their savior, their boy. There's nothing we can do now. Let's get this guy in and get him really to club the other side and help us get what we want. And they won't understand at all that that's not the mediator's role, and they will have to be disenchanted on that. Finally, there is, as we've already mentioned, the absence of the normal weapons that resolve labor disputes when you get down to the final hour, the strike or the lockout, and you don't have that in the federal level. Theoretically, you don't have it at any level, but the newspapers indicate that there's a kind of a de facto acceptance of this in some places. Now, the absence of that basic element is bound to affect the third party's role in this field. We're going to have to perhaps think in different ways and adopt new techniques. I don't believe that it follows necessarily that let me put it this way. I think that there's an exaggerated idea of the weakening effect on the collective bargaining process of the lack of the strike weapon. My experience has been that you can do an awful lot of effective bargaining if there's a will on both sides without this hanging over your head. Obviously, where you've got stubborn people, that lack will make a difference. But a whole lot of companies and unions have gone for a long time without strikes. A whole lot of government agencies and their unions have reached agreements without strikes. But there would be no point in minimizing the importance of that. Generally, the importance of that lack on the role of the mediator.